In 1925, the Tennessee General Assembly passed the Butler Act, a law which stated, in part, "It shall be unlawful for any teacher in any of the universities and other public schools of the state to teach any theory that denies the story of divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals." Dayton, Tennessee, May 1925. The town lay silent in economic struggle. The local coal mines had just shut down and the population had dropped from 3,000 to 1,800 in just 35 years. George Rapalea, who worked as the manager for the local Cumberland Coal and Iron Company, sat down with attorney Sue Hicks at Robinson's drugstore to find a way to put Dayton on the map. George noticed an ad from the American Civil Liberties Union that would provide free legal representation to anyone willing to challenge the Tennessee's Butler Act. So they got the superintendent of the local high school and John T. Scopes, the football coach and substitute biology teacher, to discuss holding a trial in town as a publicity stunt. Scopes agreed to being tried because, after all, he was teaching out of Hunter's civic biology textbook, which contained Darwin's theory of evolution, and the trial was set for July 10th. The Scopes trial was a turning point in American history because it cast suspicion on the authority of the Bible, brought the theory of evolution to the everyday American, and had a lasting influence on the science curriculum. You can't make a monkey out of me. Oh, no, you can't make a... One of the things that made this trial so intriguing was the showdown between Clarence Darrow and William Jennings Bryan. William Jennings Bryan argued for the prosecution, while Clarence Darrow, said to be the most famous attorney at the time, defended Scopes. Bryan was a three-time Democratic presidential candidate and a leading fundamentalist. He would like to see Darwin's theory of evolution banned throughout all the classrooms in America and saw it to be evil. His comment on Clarence Darrow was, "He is the greatest agnostic and atheist in the United States." The first day of the trial started like any other, with jury selection, and on the second day, Darrow argues that the law is unconstitutional. If today you can take a thing like evolution and make it a crime to teach it in the public schools, tomorrow you can make it a crime to teach it in the private schools, and the next year you can make it a crime to teach it to the Houstings or in the church. At the next session, you may ban books and newspapers. After a while, Your Honor, it is the setting of man against man and creed against creed, until with flying banners and beating drums, we're marching backwards to the glorious ages of the 16th century, when bigots lightened faggots to burn the men who dared to bring any intelligence and enlightenment and culture to the human mind. For $1,000 a day, WGN Radio set up to broadcast the trial live. It was the first live broadcast in American history. Every day, millions of Americans gathered around their radio and listened to the Scopes trial proceedings. I'm like a little tot that needs a lot of tenderness and care. I do not object to the jury or anyone else praying in secret or private, but I do object to the turning of this courtroom into a meeting house in the trial of this case. You have no right to do it. After a few days, Scopes wasn't even a part of the trial, just a figure that they needed to hold this debate. Most of the time, he would just show up and watch, just like a spectator. And with the way Clarence Darrow questioned things, it was more like creationism was on trial. The summer heat took a toll on everyone. Newspaper columnist H.L. Mencken described Dayton as having the atmosphere of a blast furnace. And because of the heat, on the seventh day, they moved outside. On that same day, Darrow calls Bryan as an expert witness on the Bible. He then questions Bryan on different stories in Genesis.
Mr. Darrow is calling Mr. Bryan as an expert witness in the teachings of the Bible. It raises, for me anyway, the fundamental question as to what relevance would his expert testimony have in this prosecution. strictly speaking, from a trial lawyer's perspective, if there's nothing relevant to what a person has to say or testify to, then by law, they can't be testifying in front of a jury.
Mr. Bryan, do you believe the first woman was Eve? Yes. Do you believe she was literally made out of Adam's rib? I do. Did you ever discover where Cain got his wife? No, sir. I leave the agnostics to hunt for her. Judge Ralston put an end to Darrow's examination of Bryan, an examination that really amounted to an attack on fundamentalism and a literal interpretation of the Bible. In a surprising move, Darrow asked for the jury to deliver a guilty verdict on his own defendant, demonstrating that Darrow's participation in this trial was more about his prosecution of fundamentalism than his defense of John Scopes. It took the jury 9 minutes to come back with an answer. We have found for the state, found the defendant guilty. John Scopes was given a fine of $100 at the ACLU as long as Clarence Darrow offered to pay for him.
When a defense attorney asks a jury to find his or her client guilty, that is highly irregular. It may even be improper. I don't see that happening today.
The trial lasted 8 days and was a media circus, attracting reporters all the way from Hong Kong and the United Kingdom. With newspapers like the New York Times giving the trial front-page coverage and WGN Radio broadcasting the trial live, millions of Americans followed the proceedings. According to Jay Larson's book, Trial and Error, The American Controversy Over Creation and Evolution, Scopes' trial shook American popular culture the way a hailstorm shakes a tin-roofed Tennessee mountain shack.
So you know that I write textbooks, and the topic of my textbooks are human biology and straight biology, both of which deal with evolution. The Scopes trial, in my opinion, was the initial media excitement over evolution. Unfortunately, that media excitement led to a large change in the way evolution was viewed by the population, by the public. Because they didn't give a scientific explanation and instead gave a social explanation and dealt with Scopes as a social commentation instead of as a scientific discovery and a scientific phenomenon, the whole idea of evolution was shifted in the public perception way back then. That shift has remained and causes now issues for people like myself who try to write a science textbook that will be used from Delaware to California, from Texas all the way up to the Canadian border. So the modern outcome of the Scopes trial for me personally has been that I cannot write one textbook for the entire United States. Tennessee and Kentucky keep changing their mind about, can we say evolution, can we not say evolution, do you have to say evolution and creationism and instructional design or intelligent design, do we have to say all of that? So in the Tennessee version we talk about it as descent with modification, and I also have to give some time, some paragraphs, to creationism and intelligent design, both of which are not scientific theories. Those of us who write textbooks and try to educate across huge boundaries really have to watch what we say and how we say it so that we are able to say other biological facts in those areas.
Immediately following the Scopes trial, fundamentalists throughout the nation wanted anti-evolution laws for their own state. By 1927, there was 13 states that had considered anti-evolution laws, and evolution almost disappeared from the public school curriculum, until 1958, when the National Defense Education Act was passed. Many legislators feared that the U.S. education was falling behind the Soviet Union. The significance of the Scopes trial as a turning point in American history was that it introduced arguments for the necessity of science in the school setting, but this recognition came 33 years after the trial in the face of a new fear greater than evolution: communism.